so you'll be...
You have these blinds at that phone?
I do. Right? So this, you don't have to ask me a question.
So just right, yeah, just right. Sit your seat. Students, so yes. For you two, as long as we don't have conflicts with any of the competitors. And before we start, if we could just have the competitors say their first and last name so we can do like a quick conflict check and then we're good to start the round.
Hello, my name is Destiny Baugh.
Hello, my name is Laniya Davidson.
Nobody has conflicts then.
Any of you undergraduate or law students at USC?
I think they're not allowed to say their school just for anonymity purposes, but as long as you don't recognize them individually, then we're good.
Okay. I stand up? I'm really short. Let's see you guys. All right. Counsel, you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
I have appearances, please.
Yes, Your Honor. Hello, my name is Destiny Baugh, and I'm joined by my co-counsel, Mr. Sam Frank.
Hello, Your Honor.
Together, we represent the estate of Mr. Peter Jones in today's case.
Good morning, Your Honor. My name is Laniya Davidson. I'm joined at counsel table with my co-counsel, Mr. Gabriel Rosella.
Good morning, Your Honor.
Good morning.
And seated at counsel table is the founder of Dragon Studios, the defendant today, Mr. Cole Doig.
Good morning.
Good morning. Please have a seat. Can you have the parties' names again?
Yes, Your Honor, Destiny Baugh.
And Your Honor, Laniya Davidson.
Got it. All right. The plaintiffs, you want to make your opening statement?
Yes, Your Honor. May I enter the well?
Of course.
Miss Davidson, Your Honor, members of the jury. One more take. That's all that it was supposed to be. One more stunt, just like the hundreds that he had done before. But this one, it felt different. The stakes were higher. The margin for error was zero. It seemed impossible. But doing things that seemed impossible, that was a normal day for Peter Jones. Mr. Jones was an accomplished actor, someone who had made his way to the top by doing the things that no other stuntman would dare to do. He gave everything to his craft, everything to his films, and he was happy to do it because he trusted his team. He trusted his crew. He trusted the film production company that had made the 6 movies before this one. He trusted the defendant, Dragon Studios. But what Peter couldn't have known is that the agreement that he had with that defendant, that the contract they signed for this stunt, it went out the window for just one more take. So on June 21st of 2023, when Peter flew off of a cliff 2,000 feet into the air, the defendant didn't have a plan to prevent him from crashing into the ground at 120 miles per hour. That lack of plan, that need that the defendant had for one more take, that's why I'm here, representing the estate of Mr. Jones and charging the defendant, or bringing a claim of negligence against the defendant. Because Mr. Jones, he wasn't your run-of-the-mill thrills chaser. No, he was a professional. These stunts, they were his livelihood. He spent years training and practicing because he wanted to make a good movie, because he wanted to make his audience happy. But with stunts like these, you have to strike a balance, a perfect balance, because all of the training in the world means nothing if the proper precautions aren't taken. And you'll learn today that those precautions, those were put in place by the defendant, or they should have been. And what I'm telling you now, that's not something that the defendant didn't know. Because you'll learn that in every film, every stunt that they hired Mr. Jones for before this one, they took those precautions. They hired stunt coordinators. They hired a stunt crew. They bought equipment. They built practice courses. But most importantly, you'll learn about the relationship that this defendant developed with Mr. Jones. Over the course of 6 franchise films, Mr. Jones and the defendant created a bond. He put his trust and faith into the defendant, and in return, the defendant made sure that he got to go home to his family every day. But on June 21st, those precautions, they went out the window. Because on the 21st, there was no time for a stunt coordinator. There was no time for practice shots. They only had time for one more take. And that's why we expect that the evidence and testimony today will show you that it's more likely than not that the defendant is liable for negligence. That is the plaintiff's burden in today's case, and it comes in 3 parts. First, we must show you that the defendant was negligent. Next, we must show you that Mr. Jones suffered harm. And last, we must show you that it was the defendant's negligence that caused this harm. Now, in order to show you that the defendant was negligent, we just have to show you that he failed to exercise ordinary care given the circumstances. So we'll show you what ordinary care is. Because like I told you, there was no plan in place for that stunt on June 21st, but you're going to hear a lot about contracts signed between Mr. Jones and the defendant for this movie. Those contracts, they included safety precautions. Those contracts, they included practice shows. They included fail-safes. And when you hear from Mr. Jones's agent, Miss Guion, you'll hear that the production company followed those plans to a T until June 21st. On June 21st, out of nowhere, the stunt changed. The plan changed. The personnel changed. All in less than 24 hours. Those changes were because the defendant needed one more shot, and that shot cost a man his life. Members of the jury, at the end of today's trial, you won't have to think about why the defendant did this, because it won't matter. The only thing you'll have to think about is every time you hear that the defendant could have taken a precaution and they didn't. Every time you'll hear that if they took the same precautions they took 24 hours before, Mr. Jones might still be alive. But members of the jury, they didn't have time to take those precautions. They only had time for one more shot. So at the end of today's trial, after all of the witnesses have testified, and before you go back to deliberate, I'll come before you and I'll fit all of the pieces together. I'll show you every place where the defendant could have taken a precaution and did. And I'll ask that you find him liable for negligence. Thank you.
Thank you. Opening argument, defendant.
May it please the court. When he made the fall, he knew it could fail. Let me take you back to June of 2022, a year before the story the plaintiff told you. Movie star Peter Jones has just finished filming his 6th installment of his majorly successful franchise. Every new movie, he does a new and exciting stunt. Hanging off the side of a mountain, climbing the tallest building in the world, parachuting in a lightning storm. And for this 7th installment, he's going to do something even bigger. He comes up with a new idea. He's going to ride a motorcycle off the side of a cliff, parachute, and land on the ground. He insists that he does it himself. No stunt doubles, no CGI. And as wild as a stunt like this sounds, for the studio, Dragon Studio he was working with, they were well equipped to make a stunt like this happen. They hired the best people, they did calculations, they got high-tech equipment, they made sure Mr. Jones was prepared. But what he was doing was no easy feat. He knew a stunt like this could be deadly. When he made the fall, he knew it could fail. We're here representing Dragon Studios. And a moment ago, the plaintiff, they gave their own description of the studio, but I want to introduce you to the founder. This is Cole Doyle. He loves movies. He loves producing, writing, filming movies for everyone to watch and enjoy. And you're going to learn today that his studio is diligent in preparing to make their stunts as safe as possible. But some actions inherently have risks that their actors sign up for. The plaintiff today, they have a burden of proof. They have to prove that it is more likely than not that Dragon Studios was negligent and that caused Mr. Jones' death. We also took on a burden to prove that Mr. Jones understood the risks of the stunt he was doing, that he chose to do it anyway, causing his death. Members of the jury, there are 2 simple facts that we will show, that will show how the plaintiff can't meet their burden and how we meet ours. The first fact, the Dragon Studio designed their stunt to be safe. Second, the plaintiff agreed to it all. Let's start with that first fact. The Dragon Studio designed their set to be safe. A moment ago, the plaintiff told you the defendant didn't have a plan for Mr. Jones' safety. But you're going to learn today that Dragon Studios spared no expense when it came to safety. You're going to hear from Mr. Doig himself that they spent over $1 million just in the safety preparations. They hired an elite stunt crew, had high-tech equipment, made calculations. Cutting corners on safety was not something that the Dragon Studio planned to do. Which brings us to the second fact, that the plaintiff agreed to it all. The plaintiff a moment ago said that on the day of the stunt, out of nowhere, the entire stunt changed. But you're going to hear today from Mr. Jones's own agent was that Mr. Jones agreed to all of the changes. In fact, you're going to learn Mr. Jones came up with the idea for the stunt himself. Dragon Studios never hid any of the details. They showed him all the safety calculations. You're going to hear that Mr. Jones knew the risks that came with a stunt like that. Members of the jury, what happened to Mr. Jones was tragic. He was loved by his family and loved by the millions of people that watched him do what he loved on screen. But what he loved to do came with risks. That's why at the end of today's trial, I'm going to ask that you find Dragon Studios not liable. Because when he made the fall, he knew it could fail. Thank you.
Thank you. Plaintiff, are you ready to call your first witness?
Yes, Your Honor. The plaintiff calls Miss Ellie Guion to the stand.
This has been sworn in.
Yes, Your Honor. And may we assume that all witnesses have been pre-sworn?
You may proceed.
Good morning. Could you please introduce yourself to the members of the jury?
Absolutely. Good morning. My name is Ellie Guion. It's a pleasure to meet you.
Ms. Guion, what do you do for a living?
I'm an agent. I work at my own firm that I founded.
And what type of firm do you run?
It's an acting firm. So my job is to take in clients who are actors and help them with their careers.
Was Peter Jones one of your clients?
He was.
How did you know Peter?
Well, he was my first client and my biggest client. I worked with him on every single one of his films, including all 6 of the All Lost movies, and over time we became good friends.
You mentioned that you worked with Peter on all Lost films. Were you working with him when he was filming that 7th movie?
Yes, All Lost 7. I was there for the entire production.
What type of movies are these?
Right, you might have heard of them. They're pretty popular. The All Lost movies, they're action-packed, they're thriller, they're suspense. They rely on the star of those movies, Travis Harper, who Peter played, to conduct these daring stunts, often defying odds. But he always comes out on top.
I want to talk about that 7th movie a little more specifically. Do you know what type of stunts were being planned for that film?
Well, for the 7th movie, the producers, they developed a particular stunt where Peter, he would motorcycle off a ramp that was placed atop a mountainside over a 2,000-foot drop. He would let go of the motorcycle and start free-falling. After about 4 seconds of free fall, he would receive a signal and he would deploy his parachute so that he could land safely.
How do you prepare for a stunt like this?
Well, we did hours and hours of training, helping Peter learn how to parachute, how to drop the motorcycle safely. We used harnesses to ensure that, but more importantly, we made sure to sign a contract and a stunt plan to make sure everyone in the studio was on the same page about what was going to happen.
Would you be able to recognize that copy of the stunt plan in the contract?
I would.
Your Honor, permission to approach opposing counsel with exhibits 33 and 34.
Please approach.
And permission to approach the witness with the same.
Yes.
Thank you.
Oh, I just handed you exhibits 33 and 34. Do you know what those are?
So, Exhibit 33, it's the contract that Peter signed with Dragon Studios, and I signed it as well as his agent. And Exhibit 34, it's the stunt plan that we agreed to.
Have they been changed or altered at all since you last saw them?
No, they look the exact same.
Your Honor, at this time we move exhibits 33 and 34 into evidence.
Any objection?
No objections.
So admitted.
Do you know what this stunt plan guaranteed Peter in terms of safety?
Yes. Looking at the stunt plan now, there were a number of precautions that ensured Peter's safety. For instance, he would have his parachute open and fully inflated before descending below an elevation of 2,000 feet above ground level. In addition to that, he'd have an earbud headphone, and 4 seconds into free fall, he was supposed to get a signal that would indicate to him he had to deploy his parachute.
Oh. Before June 21st, did you ever film this stunt with Peter?
Yes, the production crew did film the stunt on June 20th, and I was there to witness the entire thing.
Is that the stunt plan that you followed on June 20th?
Yes, to a T. I mean, Peter, he rode the ramp, he dropped his motorcycle, and 4 seconds into free fall, he received that signal.
Or how many times did Peter do this stunt on June 20th?
That stunt, it was executed flawlessly 6 times.
Well, after those 6 takes, were you done shooting that stunt?
No. See, that evening, Peter and I, we were at a producer's dinner, and the producer came up to us and said that the scene was too short. So they were going to have Peter do a longer stunt, a longer fall. And, well, Peter, he didn't answer at first. He asked questions about it.
Who was that producer that pulled you and Peter aside at that dinner?
It was Mr. Doy.
What did Mr. Doy say to Peter at that dinner?
Well, me, Peter, and him were standing sort of in the corner of the dinner, and he looked at Peter and said, You're going to wait until 10 seconds to deploy your parachute, so that we can get a longer shot.
Peter say anything back?
I mean, naturally, Peter asked if the stunt coordinator, Miss Stebbins, if she'd approved this.
And what did Mr. Doy say?
Mr. Doy said yes, that she had.
What was Peter's reaction in that moment?
Well, after Mr. Doy said that Miss Stebbins had approved the plan, Peter was silent for a bit, but then Mr. Doy, he sort of started talking to fill the silence.
And what did he say?
He brought up the press. He said to Peter, we could edit the footage together, duplicate some of the shots to make it seem like the scene is longer, but if the press asks me how low you were willing to go, should I lie to them?
Mr. Doy asked Peter if he should lie to the press. What did Peter do?
Well, it was at that point that Peter agreed to the new stunt plan. He said that he would do it.
I want to move on to the day of June 21st. That stunt plan that you have in front of you, is that the stunt plan that was followed on the 21st?
Some of the details I will say, but no, Mom, it's not.
I want to start at the very beginning. What happened when Peter got on that bike?
Peter got on the bike, and according to the original plan, he started catapulting off the ramp, and he jumped off the edge of that cliff, letting go of the bike.
And did Mr. Doy tell Peter to pull his parachute at any time during that jump?
Well, I was inside the control center, watching all of this happen, and 4 seconds passed, 9 seconds passed, and Peter, he didn't get the signal. Mr. Doy never gave him the signal.
After Peter crashed, did Mr. Doy say anything to you?
After we watched Peter fall, we took a helicopter to go see him. He was dead. I turned to Mr. Doy and I said, how could you do this? He told me he wanted a longer shot. So he thought they had more time.
Did you say anything else to Mr. Doy?
You know, I was furious. I practically screamed at him, why didn't you tell him to pull the chute at 9 seconds?
What did Mr. Doy say back to you?
Nothing. He was silent.
Thank you, Ms. Guion. No further questions at this time, Your Honor.
Thank you.
I just asked to publish exhibits 33 and 34 to the jury.
Granted. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, please.
Good morning, Ms. Guion.
Good morning.
I want to start off by talking about why you're testifying for the plaintiff. And you and Mr. Jones were close friends.
Yes, we worked together for years.
He was no ordinary client of yours.
No, he wasn't.
Like you said on direct examination, he was your first client.
Yes, I met him right when I moved to LA. He was my biggest client. We worked on every single film together.
That's right, he was your biggest client.
That's right.
Through him, he helped you make millions of dollars.
Of course, Mum, I was his agent.
And had Mr. Jones survived that crash, you would have made more from the money.
I'm not sure what I would have made if he had survived.
Ma'am, had you been able to produce that movie, you would have still been his agent, isn't that right?
Presumably, yes. We were not only good friends, but our professional relationship, it led to our success for years.
And let's talk about the safety measures of Dragon Studios. Now, you know that Dragon Studios hired a stunt coordinator.
Yes,
That stunt coordinator was supposed to design a stunt that was safe.
that's right.
That stunt coordinator designed calculations that she showed to you.
Yes, Miss Stebbins. She was part of the production crew, and she showed us the calculations for the part where Peter would be free falling off of that cliff.
And Mr. Jones, he also saw those calculations showing his free fall.
That's right. I was there when Peter was shown those calculations.
Well, you're aware Dragon Studios, they set up an entire control room for that stunt.
It's true. Yes.
They put trackers on the back of Mr. Jones and his bike.
That's right. They had a sort of GPS device that would go under his collar and also his parachute.
They paid for his practices,
Yes.
and they had him practice 12 months before ever even attempting this stunt.
Well, that's right. He was practicing components of the stunt for months before he ended up ultimately doing the stunt that killed him.
So that's for 12 months. Mr. Jones was practicing just for this movie.
That's right.
Let's talk about what he knew about the risks of a stunt like this. Well, Mr. Jones had skydived over 1,000 times, isn't that correct?
Yes, he'd skydived before for a different movie, also in the Almost franchise, and he practiced skydiving for this movie as well.
And you would agree that Plaintiff, he was no stranger to doing stunts.
No, Peter was always insistent on doing his own stunts.
Well, ma'am, you were present the day before Mr. Jones's death when he gave an interview about the stunt for this movie.
I was, yes.
In that interview, when he was talking about this stunt, he said he knew he may not survive.
That's right. He was chatting with the interviewer and he said, we decided to film the scene first because if anything happened to me, there was no point in filming the rest of the film. I didn't know how right he was at it.
That's right. Mr. Jones even stated that he chose to film that scene first because he knew he may not survive.
That's what he said.
I want to talk about what exactly Mr. Jones agreed to. Our permission to approach with exhibits 33 and 34, which have already been admitted into evidence.
Yes.
Permission to retrieve from the jury.
Yes. Thank you.
Now, that's the contract and the stunt plan that Mr. Jones signed off on, correct?
Yes, exactly.
Looking at that contract in the last paragraph, it's kind of halfway through.
Okay, then.
It says that Mr. Jones understood that there was a risk of death with the stunt that he was going to perform.
Yes, performer has elected to perform his own stunts, including driving a motorcycle off a cliff. He accepts the risks, including the risk of death.
Ma'am, he signed off on the risk of death in that contract.
Yes, it says he accepts the risk of death for the stunt plan that was attached, which was this one.
Exactly, the stunt that he accepted the risk of death for in that contract was to deploy his parachute after 4 seconds, correct?
That's right, that was the original plan.
So when Mr. Jones had to deploy his parachute after only 4 seconds, he had already agreed he may not survive that.
That's right.
And then you were there when Mr. Jones agreed to deploy his parachute after 10 seconds.
It's not quite how I put the conversation on.
Is it your testimony today that Mr. Jones did not agree to deploy his parachute after 10 seconds?
After Mr. Joy said that he might have to lie to the press if they edited footage to make it seem like the stunt was longer, that was when Peter said, yes, I can do it.
Ma'am, you just said that Mr. Doig stated he might have to lie to the press. That's not exactly what you stated on direct examination, isn't that right?
I'm sorry, that's exactly how I remember it.
Mr. Doig asked Mr. Jones whether he wanted him to lie to the press. Is that true?
That's right. He said we could splice together some footage or duplicate the clips, but if the press asked me how low you were willing to go, should I lie to them?
And after that, Mr. Jones said, I will do 10 seconds. That's what he agreed to.
Yes.
Thank you. I have no further questions. Permission to republish the exhibits 33 and 34 to the jury?
Granted. Any redirect?
No, Your Honor, we just asked that the witness be excused.
Thank you. Thank you. You may step down.
Thank you, Your Honor.
Any other evidence, plaintiff?
No, Your Honor, with that, the plaintiff rests its case in chief.
Thank you. Defense, do you wish to call a witness?
Yes, Your Honor, we call Colt Doig.
Witness has been sworn in. Counsel, you may proceed.
Good morning. Could you please introduce yourself to the members of the jury?
Good morning. My name is Cole Doig.
What do you do for a living?
I'm a producer. I own a movie company called Dragon Studios.
Now, how did you get into that line of work?
I grew up loving movies. I lived in Chatham, Massachusetts, and every summer my dad and I would go watch Jaws together. I think making movies now is kind of the way I honor him.
And how long have you owned Dragon Studios?
I've owned Dragon Studios since 2006, so 18 years now.
Do you know why you're in court today?
I do. One of our actors, one of my friends, Peter Jones, he died during one of our stunts last year.
Let's talk about the movie that Mr. Jones was filming. What film were you working on in June of 2023?
All Lost #7, actually. It's just like Allie said. All Lost, the movie franchise. We have Peter, he plays this character named Travis Harper, and he's this larger-than-life sort of action hero person. And he wanted to do a big stunt to show off what he was capable of.
And what stunt did Mr. Jones suggest that he wanted to do?
He said for the 7th installment, he wanted to get on a motorcycle and drive off a ramp, and then he was in midair, he let go of the motorcycle and skydived.
How do you prepare for a stunt like that?
I mean, how do we prepare? We do a lot. We set up this whole model set for him to practice the jump in Ontario, California. We had him practice skydiving. We had him practice jumping from motorcycles. We had him do both of those things over 1,000 times each.
Did you dedicate any other resources to the safety of the stunt?
Absolutely. I mean, jumping off a cliff for a movie, that's a big ask of anyone, and we wanted to make it as safe as we could. So we hired a stunt coordinator, we hired crew members, we had him practice. We wanted him to be okay.
Were you involved in the coordination of this stunt?
I was actually inside the control room.
Then how much money did Dragon Studios invest in the safety of this stunt?
We spent over $1 million on just safety precautions.
Your Honor, permission to approach opposing counsel and the witness with what's been pre-admitted as exhibits 10 through 12.
You may.
Thank you.
Mr. Doig, what if I just handed to you an exhibit 10?
This is a photo of the set we built in Ontario. We designed the ramp to simulate what it would be like when we actually went to film the stunt. We practiced jumping off this ramp to simulate it.
And what about in exhibit 11? What does that photo show?
You can see here on the ground, this is tarp to soften his fall in case anything went wrong during the practice trips.
And what about in exhibit 12?
Exhibit 12 is an actual photo of the stunt being practiced. We had Peter wear straps, a harness, so that if anything went wrong, he got tangled up with the motorcycle, something, anything went wrong, he'd be pulled back up and he wouldn't hit the ground.
Permission to publish exhibits 10 through 12 to the jury.
Granted.
And Mr. Doig, let's talk about what Mr. Jones knew of the risks of that stunt. Would you recognize his contract if I showed it to you?
Yes, I would.
Permission to retrieve exhibit 33 from the jury.
Granted.
Thank you.
Sir, is that the contract that Mr. Jones signed?
It is.
And are there any provisions about the risks of the stunt that he wanted to perform?
There are. I mean, Peter's a friend, he's also an actor, and we wanted to make sure that in his contract he knew what we were going to do and understood those risks.
And through this contract, what stunt was he agreeing to?
To the motorcycle jump, he wanted to jump off a ledge off a mountain and skydive down to the ground. That's what his contract was.
And through this contract, at what time did you have Mr. Jones deploying his parachute?
Based on this contract, we had him deploy his parachute after 4 seconds.
Then let's talk about the days of filming. When did you begin filming that stunt?
June 20th, 2023, we went and we found a mountain in Norway actually to begin filming.
Was filming successful for that stunt?
It was. I mean, we did the stunt 6 times successfully. He would jump off, I'd wait 4 seconds, I'd radio, pull his parachute, and land.
Were you able to get all of the footage that the movie required?
No. 4 seconds, it sounds like a long time, but I wanted a longer shot. That's true.
Sir, what did you do when you saw that you just didn't have the footage you needed?
Well, I asked our stunt coordinator if we waited for 9 seconds, would that be safe?
And what did your stunt coordinator tell you about waiting longer to deploy the parachute?
She said yes. She said 9 seconds. 9 seconds and Peter would be okay. That's what she told me.
Did you ever pitch that to Peter?
I did. I told him that evening, look, we had 6 good takes. If we wait 9 seconds, we can get a 1 take and it would be perfect. and I told him what Sky, our stunt coordinator, had told me, that 9 seconds and we'd be safe.
How did Mr. Jones respond to that?
Well, at first he was a little hesitant, but when I told him what Sky had said, he agreed. He said he'd be willing to do it.
Let's talk about what happened during that extra take. Was Mr. Jones able to deploy his parachute safely?
Peter was in the air for 9 seconds, and I radioed to him and I told him to deploy. I told him to pull, pull, pull. But he didn't. He kept falling for a few more seconds, and I told him deploy, deploy. He waited, and then when he was just 500 feet above the ground, he pulled his cord. But by then it was too late. It was too late.
Mr. Joy, I want to be very clear. Did you give Mr. Jones the signal to deploy at 9 seconds?
I absolutely did. I told him to pull his parachute. I never would have risked the life or the health or the safety of one of my actors, let alone one of my friends. Peter and I would never do that.
Was 9 seconds the amount of time that you and Mr. Jones had agreed to?
It was.
Thank you, Your Honor. I have no further questions.
Thank you.
Permission to republish Exhibit 33.
Granted. Cross-examination.
Yes, Your Honor. May I proceed?
Proceed.
Mr. Doy, you're the founder of Dragon Studios, right?
Yes.
And you work as an executive producer there as well.
Yes, that's right.
You were the executive producer for all of the All Lost films.
That's true.
You would say that it's your job to oversee everything that happens on your sets.
Yes,
That includes the safety of your crew members.
that's right.
That includes the safety of Mr. Jones.
Yes, I took Peter's safety under my responsibility. That's true.
And when you knew that Peter was going to do this big scene for All Lost 7, you felt responsible to ensure that he was safe.
Yes, I hired stunt coordinators, crew members. I went in and practiced it. That's true.
Right, you hired an entire stunt team.
Yes,
You hired stunt coordinators.
yes,
You did calculations to see exactly how fast he'd be falling.
that's right.
You purchased all of the practice courses and all the equipment that he would need.
Yes,
And you made a stunt plan.
that's true.
You recognize that stunt plan if I showed it to you?
Yes, I would.
Permission to approach the jury and retrieve Exhibit 34.
You may.
And to approach the witness with the same.
Yes.
Thank you.
This stunt plan, that's the plan you followed on June 20th, right?
Yes,
In this stunt plan, there are certain precautions that you promised Mr. Jones you'll take.
that's true.
And when you completed all 6 of those dives on June 20th, Mr. Jones was still alive.
That's right.
That wasn't good enough.
The stunts or Mr. Jones being alive, man.
Those 6 stunts you did, they weren't good enough.
Yes, that's right. We wanted a longer take.
You wanted a longer take.
That's right.
You felt pressure to keep one-upping your previous work.
We wanted a longer take for a better scene. That's true.
So that's a yes to my question. You felt pressure to continue topping your previous work.
That's right.
And so that's why you pulled Peter and his agent aside at that dinner.
Yes.
Now you just told the members of the jury that Peter asked you if the stunt coordinator thought it was going to be safe.
That's right. I had talked to her earlier in the day about doing a 9-second jump.
And you told Peter that she greenlit it.
That's right. She did.
It's not exactly what she said to you, though, was it?
Exactly what she said. She gave me the green light.
Well, what she said was, I don't recommend it, right?
Yes, but she said it would be safe.
So you didn't tell Peter that the stunt coordinator actually said, I don't recommend it, but it might be safe.
I told him exactly what she told me.
What you told Peter was that she greenlit it.
That's right.
You didn't tell Peter that she said she didn't recommend it.
No.
Now, I want to move on to what you actually did on June 21st. Because that stunt plan, it had Peter doing 500 dives and 500 jumps before his stunt on June 20th.
Yes.
But the stunt on June 21st, it wasn't the same as the stunt on June 20th.
That's true.
You wanted Peter to wait almost twice as long before pulling his parachute.
Yes, we changed it from a 4-second jump to a 9-second jump.
You wanted him to get 1,000 feet closer to the ground before ever pulling his parachute.
That's true.
Now, when he only had to wait 4 seconds to pull his parachute, you had him do over 1,000 practice runs. He didn't do any practice runs before June 21st, did he?
No.
And that photo that you showed the members of the jury with the crash pads, Peter didn't have any crash pads before that June 21st jump, did he?
No. That was the real thing.
Oh, Peter, he also was guaranteed that in that stunt plan, that his parachute would fully inflate before 2,000 feet, right?
That's right. That's what we said in the stunt plan.
That's actually the industry standard.
That's true. The industry standard depends on the experience of the skydiver. For amateur skydivers, 2,000 feet is what's recommended.
I want to be clear, the industry standard, it's 2,000 feet even for experts.
No, it's
Objection,
different.
Your Honor, to improper expert opinion.
Overruled.
No, it's different for elite skydivers.
Is it your testimony today that the industry standard is higher or lower for elite skydivers?
Yes, elite skydivers can skydive safely up to 1,000 feet above the ground.
You remember preparing the deposition for today's trial?
Yes.
Approaching the opposing counsel with the witness's deposition.
Yes.
Permission to approach the witness with the same.
Approach.
Thank you.
Oh, that's your deposition, right?
Yes, ma'am.
And you remember being sworn when you made this deposition?
Yes.
And you could turn to page 74 with me, line 197, or 195. Starting with that question on 194, if you could read silently as I read aloud. As of June 20th, 2023, why did you understand those figures to be important? Because I knew the industry standard is that skydivers should have their parachutes open and fully inflated before the elevation gets lower than 2,000 feet. That's the recommended limit, even for experts. It's a safety thing. Did I read that correctly?
Objection, Your Honor, under Rule 106, Rule of Completeness. Your Honor, there's a little bit more to the answer that he gives in there. It says, but elite skydivers, like Peter, can survive skydives if their parachutes are fully inflated before they descend below 1,000 feet. It eliminates a lot of margin of error, but it's doable. That's the full answer. Just ask that they give the full answer for that question.
Response, Your Honor.
Respond, please.
Your Honor, the question that I asked Mr. Doy was if 2,000 feet was the industry standard. He said no. That quote at the very end does not need to be considered in fairness with the original part of his testimony because it's an addition that does not answer the question that I asked him, which was the contradictory statement.
Overruled.
I can take that back. Now, in that stunt plan, you tell Mr. Jones that he will have his parachute open before 2,000 feet.
Yes, in the stunt plan.
But when you changed the stunt on June 21st, you violated the industry standard.
No.
You didn't have Mr. Jones open up his parachute until he was nearly at 1,000 feet.
That's right. Mr. Jones was an elite skydiver, and skydivers can skydive up to 1,000 feet off the ground.
Sure, Mr. Doy. But you know that Peter, he wasn't responsible for the safety of his own stunts.
He takes on some responsibility when it comes to when to deploy his parachute, to pull the cord. He has an active role in this.
But he's not the one who picks his equipment.
That's right.
He's not the one who checks to make sure his equipment is safe.
That's true.
He doesn't plan out any of his dives.
That's right.
He doesn't assess the safety of any of his dives.
No, we have a team to do that.
He trusts his stunt coordinator to do that, right?
Yes, and we trust the stunt coordinator to do that as well.
On June 21st, his stunt coordinator wasn't there, was she?
That's true. We consulted with her the night before about whether it would be safe, and she gave us the go-ahead.
The only person in his ear on that day was you.
Yes.
And you were here, and his agent testified.
Yes.
You heard her say that you didn't say a word to Peter.
I heard her say that. That's right.
No further questions, Your Honor. Permission to republish Exhibit 34.
Granted. Any redirect?
Yes, Your Honor. Mr. Doig, I just want to be very clear. When you changed the stunt from 2,000 feet to 1,000 feet, did Mr. Jones agree to that new stunt?
He did.
Did you inform Mr. Jones about what he would have to do for that stunt?
Yes, he did.
Did Mr. Jones ever say he didn't want to do that stunt?
No, ma'am.
No further questions.
Thank you. I'm going to step down.
Yes, ma'am.
Any further witnesses, defense?
No further witnesses. Defense rests.
I am going to take a 2-minute court recess. Parties, counsel, get your arguments ready. Resume when I get back. record, plaintiff's closing argument.
Yes, Your Honor. May I proceed?
Yes.
On June 20th of 2023, Peter Jones was doing the one thing that made him adored by millions. A new stunt for everyone's favorite action movie. He was supposed to ride a motorcycle off a cliff, launch himself into the air, and land on his feet. The crazy part is he did it. But he didn't just do it once. He didn't just do it twice. He didn't do it 3 times. He did it 6 times. And the only way that something like that is possible is when you have a team. On June 20th, Peter had the team that he had for the 6 movies before this. He had a stunt coordinator. He had a crew. He had an executive producer who made sure that they were following their stunt plan. And if that was the end of the story, I wouldn't be here today. But the reason that I'm here and Mr. Jones is not, is because that wasn't enough. Is because when the defendant looked at that footage, it wasn't good enough. The need to go big or go home had become an obsession, and a man was going to lose his life for it. On June 21st, the plan went out the window. The defendant went up to Peter and he told him, one more take. Wait a little bit longer, one more take, and it'll be perfect. The defendant had worked with Peter for over 6 films. The defendant knew how much Peter wanted to make his audience happy, how far he was willing to go to be the guy who did what no one else would do. And that's why Peter said yes. Well, opposing counsel wants you to believe that Peter said yes because he knew the risks. That he knew the risk that he was taking when he decided to wait until he was almost 1,000 feet from the ground before pulling that parachute. But there's 2 problems with what the state just told you. The first is that Peter couldn't have had knowledge of that risk. Because when he asked the defendant if the stunt coordinator said it was okay, the defendant said, "You've got the green light." What the defendant did say is that the stunt coordinator did recommend that they go on with the shoot the next day. You heard the defendant say that Peter, he was the stunt guy. He wasn't the one doing the calculations. He wasn't the one checking the equipment. He wasn't the one planning the dives, because he trusted the team that was doing it for him. And that misplaced trust, that is what got Peter killed. The second problem is that Miss Davidson, she told you that they hired the right crew, they did the right calculations, that they had the right plan. All of those things are true for 24 hours before the stunt that killed Mr. Jones. You heard today that on the 21st there was no stunt plan. That the stunt plan that they had been using for the 6 takes before that, the stunt plan that worked, it went out the window. He got no practice jumps. There were no landing pads. The stunt coordinator wasn't on set. This was completely different terrain. And that is why we charged the defendant with negligence. Oh, we talked about those 3 parts of negligence earlier, but I want to walk through them one more time. Because the first thing you needed to find was that the defendant was negligent, or that they failed to exercise ordinary care given this circumstance. But what's ordinary care? Remember to the jury, luckily for us, the defendant wrote the book on ordinary care just 24 hours before the stunt that killed Mr. Jones. These stunt plans, they've been in place, they've been working for 6 movies. These stunt plans were made to ensure the performer's safety. And the moment that this stunt plan was deviated from, the moment that the defendant decided he needed one more shot, that's when a man lost his life. Next, we had to show you that there was harm. We all agree that Mr. Jones died as a result of that crash. The last prong is that the defendant's negligence, it was the cause of that harm. To prove that, you only have to look 24 hours before. 6 times, a man threw himself off of a ramp in 2,000 feet to the air 6 times and landed perfectly. That plan, that contract that you're going to get to go take back with you, that's why he landed. It's not a coincidence the moment that that plan went out the window, Mr. Jones lost his life. That's why at the end of this trial, we will ask that you find the defendant liable for negligence. Thank you.
Thank you. Closing argument, defense?
Yes, Your Honor. May it please the court.
Yes.
Members of the jury, we all wish that Mr. Jones was here with us today. We all wish that he could still be making the movies that he loved to make. We all wish that this tragic accident never happened. Members of the jury, when Mr. Jones got up there on the top of a mountain, he knew what he was getting himself into. Now, while the plaintiff today has tried to claim that we hid the risks for Mr. Jones, there's one thing that you never heard at all today. You never heard a single person forcing the plaintiff to jump off of a mountain. In fact, what you heard today was that the day before he lost his life, he was telling a magazine that that jump could be his last. Because when he made that fall, he knew it could fail. The plaintiff today, they had a burden of proof to show it was more likely than not that it was Dragon Studios' actions that caused Mr. Jones' death, that their negligence was the cause of that fall. We also took on a burden today to show that Mr. Jones understood what he was getting himself into. He knew the risks, and he did it anyway, and that caused his death. At the beginning of today's trial, I pointed out 2 facts that we showed you that prove why the plaintiff can't meet their burden and how we met ours. First fact, Dragon Studio designed a stunt that was safe. Second, Mr. Jones agreed to it all. So let's start with that first fact, that they designed a stunt that was safe. Because all today, the plaintiff has been telling us that what he did, lowering the jump from 2,000 to 1,000, it was unsafe. But members of the jury, you haven't heard a single person in trial today testify that 1,000 feet was an unsafe level to jump at. In fact, you heard that an elite skydiver like Mr. Jones, someone who skydived 1,000 times, could do a jump at 1,000 feet. It wasn't the jump that was dangerous. You heard today from their own agent, Ms. Guion, that they had calculations. They had a stunt coordinator. And while they tried to say that the stunt coordinator didn't recommend it, she did greenlight it. She did say it was doable. And so that's what Mr. Doyle told Mr. Jones. That's what Mr. Jones agreed to. Now, the plaintiff, they had to prove today that it was that change from 2,000 to 1,000. They're saying was unsafe. That's what caused Mr. Jones's death. But you heard today, they tried to execute that plan. But Mr. Jones, he waited too long to pull his parachute. We don't know why that happened. We don't know what happened in the air. We don't know what he was thinking. But he didn't follow the new agreed upon plan. So the plaintiff, they haven't shown that it was the change in plan that caused Mr. Jones's death. And that brings us to our second point. Mr. Jones agreed to it all. All today, they've been saying that this new change of plan, it came out of nowhere. They tried to tell you that Mr. Doig told Mr. Jones, we need another shot. But that's not exactly what happened. You heard today that Mr. Doig asked Mr. Jones for that other shot. Asked if he wanted. He told him, I could splice the photos together. We could make it artificially longer. Mr. Jones said, I'll do the 10 seconds. He agreed to the 10 seconds. And you saw earlier today that in that original plan, when he was supposed to deploy his parachute at 4 seconds, he agreed there was a risk that he might die. So when he agreed to do 10 seconds, members of the jury, he didn't think it was any safer. He didn't think suddenly that the jump was going to have no risk of death. He knew what he was getting into. He'd done it many times before. He was an experienced skydiver. He knew it was a dangerous stunt. That's why he wanted to do it. He wanted to push the limits, and he wanted Dragon Studios to be right there alongside him. Members of the jury, this is the verdict form. Let's walk through it together. The first question was for the plaintiff to prove. Did they prove that Dragon Studios was negligent and caused Mr. Jones's death? You heard today from their own witness, they hired stunt crews, that they did calculations, they had high-tech crew. They spent over $1 million to ensure his safety. And not a single witness today testified that it was the change in plan that caused Mr. Jones's death, that change in plan was unsafe. So where it says, did they prove negligence, you can check no. The second question was for us to prove. Did we prove that Mr. Jones understood the risks of that jump, that he did it anyway, and that caused his death? You learned today that every change, every stunt, Mr. Jones agreed to it all. Members of the jury, you can check yes. In cases like these, sometimes we want to find someone to blame. But what happened that day, it was a tragic accident, and the plaintiff knew. When he made the fall, he knew it could fail. That's why we ask that you find Dragon Studios not liable. Thank you.
Thank you, everyone. Excellent job. Oh, you're going to get one more.
Yes, Your Honor.
Sorry to cut you off. Go ahead.
Miss Davidson just got up here and told you that the risks of this jump, they weren't hidden. Members of the jury, when Mr. Doig took the stand, he tried to hide those risks from you. He told you that the industry standard was lowered for experts despite direct evidence that it wasn't. The same way, he told Mr. Jones that this stunt was safe, despite it going against professional recommendation. Find him liable. Thank you.
right. Good job.
Yes, let's just make sure everybody's submitted their ballots.
Good idea.
And once you see the screen that says you've submitted